anyone in the audience who is not connected with data in the electronic form? If there is anyone, please raise your hands. Sure. Not a single hand. So we are all connected with data. We are relying upon data. And while this is happening, a lot of new developments are taking place. I wanted to take you through what's happening. But before we get started, how many of you are not using ChatGPT? Please raise your hands. Okay, so I see about 2-3 hands. So the default option is everybody else is using ChatGPT. So the next time ChatGPT gives you a data and you put that as your own, what kind of ramifications could that have for you? Recently, a company decided they wanted to get some sales programs and proposals. They asked the sales team to do so. The sales team uploaded the complete corporate data onto ChatGPT, got the stuff back, and cut, paste, and put it back in the company's account. Little did they realize that they were actually giving so much of corporate data out there, which is bound to create its own legal issues and challenges. So in this context, when I talk about data protection, I'm in a different ball game altogether. First and foremost, this particular slide tells me that 12,000 SBI employees' sensitive personal data has been leaked on Telegram channels and still is available. Okay? Is it normal data? No, it's sensitive personal data. Talk about Prime Minister Narendra Modi recently announcing that the Indian data protection law is now going to be a great leaping step forward because it's going to help increase India's reputation globally. And the monsoon session is coming in, and the new Digital Personal Data Protection Bill 2023 is listed for being passed. This particular bill has got a distinctive journey. Last 5-6 years, we have been deliberating various options, various drafts of this bill. And we have now reached at a reasonable level of maturity on how we want to go forward. First and foremost, I need to give you a caveat. The caveat is that at the time when I talk to you today evening, the final draft of the Digital Personal Data Protection Bill 2023 is still not out in the public domain. So it's hard to really comment on the exact parameters of this bill till such time the exact draft is going to be out. But my knowledge is again going to be limited to what's happening in the public domain. I take you back in 2018 when the government had appointed Justice Sri Krishna committee. The committee had come up with a report and had come up with a personal data protection bill draft in 2018. From those days till 23, it's been a long journey. We've actually now seen this new bill. The last version that we know is the draft Digital Personal Data Protection Bill 2022. And therefore, whatever I'm going to talk is again based on those elements and what I see in the public domain. First and foremost, for the first time, a very expansive definition is being given of data principal. Who's a data principal? It's any individual about whom the personal data relates to, and also includes a child below the age of 18 years, also includes the parent and even the lawful guardian. For the first time, they've gone ahead and defined what is personal data. And this personal data is any data about an individual which is identifiable by or in relation to such data. So just about anything which identifies a particular individual gets within the parameters of personal data. Now, for the first time, this particular law is going to actually stipulate data fiduciaries, whether you are within India or whether you are outside India, to provide data principals with a notice, stating a couple of things. Number one, that the personal data is about to be collected. Number two, the purposes for which personal data is being collected and will be processed. And this has to be provided either on or before the exact moment when you're requesting the data principal's consent for proceedings. So in India, we are all from the joint family setup. We love to share information. And in this ecosystem for the first time, the law is saying that my consent will have to be taken. And this consent will have to be very, very crucial. You don't comply with this law, don't worry. Just tighten your belts. Why? Because be prepared for fines ranging from 150 crore rupees to 500 crore rupees per contravention. And I can tell you, one fine will be more than enough to wipe out a large number of companies. So it's no longer just a luxury kind of a law that you have to think of. Here is a legislation that promises to change the landscape for all times to come. It's actually requiring every personal data breaches to be reported to every affected data principal. And non-compliance, they are saying currently a penalty of about 200 crore rupees. Actually, we took our leaves and our inspiration from the General Data Protection Regulation of the European Union, where they have actually gone ahead and fined 4% of the annual global turnover of companies. We are going beyond. The most populous nation in the world is now saying we are going to have express consent, and we are also going to have deemed consent of individuals. It is actually allowing all kinds of companies who are data fiduciaries to go ahead and process personal data based on the consent obtained from the individuals. And further, the consent has to be free, fair, specific, informed, and unambiguous. These elements will have to be followed. So every time your company is collecting information, which is personal information about your customers, about your clients, about your partners, you will now have to ensure compliance with this law per se. Also, for the first time, we have this concept of deemed consent. One is you take my real consent, and I give you consent, please process my data. Second is no, you have a deemed concept. The moment I do certain things, I'll be deemed to have given my consent. And therefore, they've gone ahead and recognized some standard grounds which are there in other jurisdictions for compliances for data principles and data objects. But the problem is this entire deemed concept has been very, very much gray zone. It's vague, it's ambiguous. So at which point of time will my consent will deemed to be deemed consent is a gray zone. We'll have to wait to see the final draft of the law. It actually is coming up. A lot of people who criticize the draft bill 2022 said it's in violation of people's fundamental right to privacy, to informational privacy, and it goes against the specific consent principles which have been given in the landmark judgment of Justice Puttaswamy versus Union of India. But a lot of critics are saying this deemed consent could be potentially misused. So we will have to wait and watch how this deemed consent is actually evolving, because the principles of privacy are now well established. We all have right to privacy as a fundamental right, thanks to 9-judge bench of the Supreme Court judgment in Justice Puttaswamy versus Union of India. Further, if you are a data fiduciary, and every company who's present here who will be dealing with personal data will become a data fiduciary, you would be required to take reasonable steps to ensure personal data is processed by them or on their behalf, accurate and complete. So you are going to be held responsible if the said data is not going to be accurate or complete. And it's likely to be used by the data fiduciary to make a decision that affects the data principle and is likely to be discussed by the data fiduciary to another data fiduciary. So cybersecurity is very important. Already under the IT Act, we've talked of reasonable security practices and procedures. Something similar is being mirrored out here in the form of the mandate to follow reasonable security practices and safeguards to prevent misuse of personal data. For a lot of companies who were feeling very, very tight and arrested because there were data localization requirements, the press is now reporting that virtually there's now no data localization. So if you're a global company, you can actually send your data to almost any countries, barring a couple of countries, which the government is going to do. Well, it's completely contrary to what RBI is doing, but again, we have to wait because this is information in the public domain. So it's being now reported that all personal data may be transferred outside of India to countries that are notified by the central government. And once the government says this is a good jurisdiction, this is a safe jurisdiction, no problem. You can actually send the personal data of Indians to that jurisdiction as well. One thing is not clear. What happens if there's a conflict between the Data Protection Bill and other laws and the IT Act? Well, it's being reported that maybe this data protection law will have a special status, but there's a problem because there are immense kind of data localization requirements in other laws. So what's going to happen? We'll have to wait and watch how the harmonious construction is going to take place as we go forward. But I think as a student of law, I've been working in cyber law for the last more than 3 decades. I can tell you there's huge conflicts between the Information Technology Act 2000 and the proposed DPDP bill. And one thing that we must do as India, as a nation, is to ensure that these conflicts must be appropriately harmonized. Because, why? The Indian cyber law, the IT Act, is India's mother legislation for everything and anything in the electronic form. Now, with AI coming in, and I'm generating my data on AI, who's going to have the rights to the same? Can I have my data generated? For example, I'm telling ChatGPT, here is my life story, here is my pictures. Please prepare something personal for me. It prepares something personal for me. Who has the rights to the same? How will those rights be appropriately addressed in the context of generative AI and AI in general? I think those are issues that hopefully this new legislation should be thinking about, but whether it does or not, we have to wait and watch. But nonetheless, I'm very, very clear. The parameters of due diligence of cybersecurity will have to be more elaborately dealt with under the new law. Again, we'll have to wait and watch what happens, because now with GPT-4 coming in, we are on a different pedestal altogether. When I'm paying $20 a month for this very accurate service, and I'm giving my sensitive personal data to GPT-4, and the data is getting generated, where is my consent coming from? Can that data be used by GPT-4 against me? Can my profiling be done? Can my privacy be violated? Those are fundamental questions that are beginning to be raised on the horizon. Well, when you get 100 million users in a very record time, obviously, you are the rage of your times. But then, the relationship of ChatGPT and data protection is something that the world is only beginning to grapple with. But clearly, given the fact that India doesn't have a dedicated law on cybersecurity, I think the marriage between data protection and cybersecurity will have to be very, very crucial as we go forward. And I expect some major parameters on cybersecurity to be an integral part of this data protection law. Can I say one thing, which is that the new data protection law is India's march towards a new cyber world order. Why? Because we are actually representing to the world, hey guys, we are not just the country with the most number of population in the world, but we are also leading by example. And we are going ahead and coming up with new focused areas. Hence, in this entire ecosystem, I believe capacity building becomes a matter of immense concern for all data stakeholders. Started a platform called cyberlawuniversity.com. I offer about 37 courses online on cyber law, cybersecurity, cybercrime, AI. And then these courses tend to have been done by more than 28,500 professionals from 174 countries. One figure, just to tell you that there's a need for massive capacity building. And I think more so in the light of this data protection law, we will all have to create our capacities. I don't create capacities, no problem. When I am faced with a fine of 200 crore rupees or 500 crore rupees, that's the time I'll realize it was a penny-wise, pound-foolish area not to go into capacity building. So all said and done, we are still in the waiting stage. We'll have to still wait for the launch of the exact text of the draft Digital Personal Data Protection Bill 2023. Once the language comes, we will have more clarity. But the way things are currently happening, it looks very likely that this is going to be passed in the monsoon session. And if that gets passed, it's going to be the law of the land. So every company who's either located in India or outside, or who's got interest in India, will have compliance with this law. But mind you, you'll have to comply with this law and also comply with your requirements as an intermediary under Section 21W of the Information Technology Act 2000. So please be now prepared for a new age of more compliances, for more legal exposure. And today we are talking of CIOs. I think CIOs need to tighten their belts. Because today, whenever the breach takes place or whenever a legal action takes place, the first person to be picked up or to be actually notified is the CIO and the CISO. And of course, they're also potentially now being litigated. So be prepared, because next time over, in a litigation, you would not be named as CIO of a company. You are likely to be named as your own individual self, in your own individual capacity, which could open up Pandora's box of legal exposures. So I think the only mantra is just ensuring compliance. And well, let's wait for this new law. There's no denying the fact This is going to be momentous. It's going to be landmark. But all the time, it'll have to also ensure that we will have to be on the tip of the iceberg. We'll have to be constantly looking at our approaches of how our companies are ensuring compliance. In our country, please realize one thing. The Indian IT law is about 23 years old. We amended it once in 2008. Now this new law comes up. 2 years back, we had the IT Rules 2021 coming in. Last year, we had the IT Directions 2022 coming in. So the game is set. Huge areas of nets have been now put up. These are time bombs that have been put up. And therefore, it's incumbent upon every company to ensure that you do documented compliances. Because if you don't do that, then it could be a very expensive proposition. Two things. Why? You don't do compliance, then under the normal IT law, you can be, sent to jail, from imprisonment ranging from 3 years imprisonment to life imprisonment. You can face unlimited damages by way of compensation. But that's still unlimited, and nobody has yet been given more than 15, 20 lakh rupees or something like that. Now, contradistinguish that with the new data protection law, where you're looking at 200 crores, 250 crores, 500 crores as fines. And then as fines takes place, there will be huge issues. So all said and done, I think it's a great moment of realization. Let's be prepared. But again, let's wait to see what is the final language. But whatever be the language, and howsoever the law is passed, it'll be our incumbent responsibility to ensure that we protect our data, we protect our privacy, of the data privacy right of individuals whose personal data is being collected, and all of us are collecting data not only about our own selves, but also about others. So just compliance, compliance, and compliance will be the only mantra as we go forward. Thank you, ladies and gentlemen.